Hey everybody, John Skiba here, and welcome to Thursday night. We're here once again on the Consumer Warrior YouTube channel, where each and every week I do a live Q&A. We discuss everything related to debt collection lawsuits, bankruptcies, defense work, all that kind of stuff. And so the way that we do this each week is if you have questions that you want to go over and questions that you want to discuss, go ahead. If you're on YouTube, you can put them in the chat. If you're on Facebook, I haven't figured that out yet. So you can go ahead and put them there on the chat, and I'll put them up on the screen and we'll talk about it. Each week I do give my disclaimers, which I know the regulars are probably sick of the disclaimers, but that's what attorneys do best. We disclaim things. And that I'm a licensed attorney in the state of Arizona. I do help people with bankruptcies and defending debt collection lawsuits here in Arizona, but I'm not licensed anywhere else. And so particularly if you're not in the state of Arizona, you got to find an attorney to get legal advice from them, because I don't know the laws in every other state. And it's important that you get good advice. This is not advice. This is just people talking on YouTube. So take it for what it's worth. If you are in the state of Arizona, I do free consultations. I'd be happy to talk to you and kind of put together a game plan and even help you with your case. So each week, like I said, I like to go through the comments that people have put to the various videos that I post. And if you subscribe to the channel, which I encourage you to do, I've actually ramped up the number of videos that we're able to put out. I hired a video editing company that helps me tremendously because I don't have to edit all the videos. And so I'm putting out 3 new videos a week. But one of the questions that I got was this one. This one says, a question I've been looking for the answer and have not found is, does the SOL, that stands for statute of limitations, apply to the state? Got to get up above the little Chiron thing here. Does the statute of limitations apply to the state you currently live? Because I moved from one state to another and not sure which statute applies. So this is a great question. And this is a question that a lot of attorneys make a mistake and run into some problems with. So the statute of limitations, again, that's the amount of time that a creditor has to sue you after an account goes into default. And so if the account goes into default, you miss your payment 30 days later, now they have a certain period of time to file the lawsuit. And if they don't do it, they're forever barred from doing it. So it's important to know which statute of limitations applies, because it's different from state to state. So for example, in the state of Arizona, a 6-year statute of limitations is applied to credit card debt. They have 6 years from the time the account goes into default to actually file the lawsuit. Well, what if you live here and then you move to another state and the other state has a 3-year statute of limitations or a 4-year statute of limitations? Then you get into the question, which law applies? Which one are you going to be able to use? Because it's going to make a huge difference whether your case gets dismissed or whether the creditor is able to go forward. And then we can throw an additional complicating factor in there. In the terms and conditions of the credit card, there's usually what's called a choice of law provision, which means that they're stating that usually it's like the laws of Delaware or the laws of California or whatever, that's what actually applies to the contract. So then you get into this really difficult situation of a question as far as, how do you know? I can tell you this is a difficult area of the law, but it breaks down into whether the courts or the state views the statute of limitations as a procedural law or a substantive law. And so procedural laws are things like the rules of civil procedure, things that just kind of how the court deals with its caseload. And substantive laws are ones where, it's actually substantive rights are at stake, and it's really kind of the meat and the core of the actual statute and what the law is. Now, most courts across the nation have interpreted the statute of limitations to be a procedural law. And because of that, they usually use the law in the state where the case is being heard. So this could benefit you or it could hurt you. So for example, if you live in a state, and I don't know all the statute of limitations, but let's say that some state where there's a 3-year statute of limitations on credit cards, and then you move to Arizona and the creditor sues you and it's been more than 3 years, they're likely to apply the statute of limitations from the state of Arizona. So it's usually a procedural law from the state where you're actually at. And there's that other issue that sometimes in the terms and conditions, it'll say, the laws of Delaware will apply to this agreement. That's actually not super helpful either, because in most situations, that only applies to the substantive law, not the procedural law of the particular jurisdiction. So that's a great question. It's one that gets a little bit complicated, but something that people run into all the time. So, all right, let's jump into it. We got Laura here. Laura, regular here on the channel. Hi, John. I have a trial date early August with Capital One, and I want to negotiate a lump sum settlement, hoping for 60%. When and how can I bring this up and execute? So settlement can be negotiated at any time. I mean, you could reach out, Laura, you could just reach out right now, reach out to the attorney that's handling the case. And frankly, a lot of times, particularly if there's a trial that's already been set, they want to get it off their calendar. The attorneys do. They don't want to have to prepare for it. They don't want to have to, particularly the debt collection firms, they deal with a lot of cases. They have heavy caseloads. And so the quicker they can get it off, the better. So you may get a better deal just because you're dealing with it now instead of waiting until, a week before trial or something like that. So I would reach out to them. I would offer them, whatever you feel like you can afford. If you can do it in a lump sum, you're going to get a better deal overall. And, settlement discussions are not admissible in court. The rules of evidence, Rule 408 in most states, states that these settlement discussions are not something they can drag into the, into trial. So if you generally don't have to worry if you reach out to them and say, hey, I'll offer you 40% lump sum. And then, they're going to turn around and say, hey, judge, she already offered us 40%, clearly shows the whole amount. They can't do that. So there's no real harm in doing it. I would reach out, though, and be prepared, particularly with an original creditor. They usually want some kind of hardship or some type of explanation to know why it is that they should take a discount on this. Because original creditor lawsuits, as I've generally said, unless you have something like an identity theft or something that's going to make it so that that you can get the case thrown out, they're probably going to get their judgment, and they're going to get attorney's fees on top of it. So it's usually in your best interest to try to settle it, particularly if you have a trial set on that. So, all right, let's see here. See what this one says. Hi, question about disputing the debt after a lawsuit has been filed but not served yet. So the Fair Debt Collection Practices Act, the FDCPA, does allow you to dispute debts or ask for verification of the debt, and the creditor then has to provide you with documentation and respond to it. Now, once the lawsuit is filed, but it's not been served, my general opinion is if it's been filed is to either accept the service when it comes to the door, or to just reach out to the other side and tell them you'll accept service and set up a time when they can drop it by. The reason is I think that you have a better chance of just dealing with it head on rather than just hope. Some people will try to dodge service, and generally that doesn't work out. They end up with a default judgment against them and getting their wages garnished, and then coming to me and asking me to try to unwind it. And in a situation like this, you can dispute it. You can still send a dispute to the creditor. They'll probably still send you some information about the case. It's not going to stop the lawsuit if it's already been filed. They're going to go and try to serve you. So my recommendation would be to deal with it head on. So, all right, let's see what J Phone has to say. Would it be better in the judge's eyes if you file a complaint for private arbitration and pay the $250 fee with JAMS or AAA, even before even being sued? I think that the better route, if you're trying to resolve it, I would say reach out and try to settle it. Reach out to the creditor and try to get something resolved. If you file for private arbitration in AAA or in JAMS, the two private arbitration companies, the thing is you have to have a claim against them. And that's where I always struggle with judges that think that the defendant needs to be the one to actually file the complaint. Typically, you don't have a claim against, Capital One or whoever the creditor is that you're taking to arbitration. If they have a claim against you, they should file it. And if they file a lawsuit in a court and you're filing a motion to dismiss and compel private arbitration, you're just telling them, hey, judge, their contract says if they're going to come after me, they got to come after me in this forum, in the arbitration forum. So I don't know if I would do that, just because I don't know what you would put in your complaint, unless you were seeking some kind of declaratory relief or something like that. I think I would just reach out and try to settle it and then wait and see. Because sometimes I'm surprised. you think that a lawsuit's imminent and then it never comes, and the statute of limitation comes and goes. And largely that's because these debt collection firms just have huge volume they're dealing with, and sometimes they just decide not to move forward with it. So that's what I would do. All right. Dave Lamb, back in the saddle. Welcome back. Back in the country on a new Google account. One question. My Chapter 7 filed in Yuma on January 21st and discharged on June 21st. I thought it was over and behind me. But today in the mail, I got an email from a creditor that was discharged trying to collect, forwarded to my attorney in Mesa. Okay, so that kind of situation, it does happen sometimes. There's kind of two options that it could be. The credit. So once the bankruptcy is over and the discharge is entered, the court mails that out to the creditors and it tells them, hey, your debt's done. You can't try to collect on it. So you could either have a rogue creditor who's just doing their own thing and saying, you know what, the heck with the court, I'm just going to still try to collect on this anyway. Or you could have a creditor who didn't receive notice, or they weren't listed in your schedules, your bankruptcy schedules. So I don't see very often the first kind that are just like, screw that, I'm just going to still collect on it anyway. Because if they do that, the court can just hammer them, and they're going to end up writing you a check over the whole thing. You can bring them in for a discharge violation and try to get sanctions against them. So I don't see it that often. I think you did exactly what you need to do. I would forward that to your attorney and have them take a look at it so that they can reach out to the creditor. I usually will do kind of a shot across the bow saying, hey, the discharge is entered, you got to stop this. But that is super frustrating. You go through the whole process, particularly yours looks like a little bit longer than normal. And then you still have a creditor reach out. But usually that can be resolved with an email or a phone call kind of thing. So, all right, let's see here. See what tiny limo. So what happens if someone files a motion to compel private arbitration and the judge does not dismiss the case because the plaintiff filed for a stay and the judge grants a stay? This is fairly common. So I do see the judges do this. Instead of just dismissing the case, they say, okay, we're going to put it on hold for 90 days. Go do your arbitration. If you do the arbitration, then we'll dismiss this. And then they say, but if you don't do arbitration, then we're going to come back and we're going to litigate it here in the court. Here's what I would want to get instructions from the court ahead of time as part of that order. And you could even, if they've already entered an order, you could ask for a clarification saying, judge, that it's got to be the creditor that files it. Going back to what I was just saying, if Midland Funding is suing me and I don't have any claims against them, we're not in this courthouse, but for Midland Funding filing this lawsuit, it doesn't make any sense that I would then go and file a claim in private arbitration. Midland's got to go be the one to file it. They don't want to file it because the filing fees are super high. Now, you could do it, I guess. You could go in and you could pay your $250 and see if the Midland's going to come in and pay their $2,500 to pursue this. I don't think they will. But I would ask for an order when you dismiss it, requiring the plaintiff be the one to initiate the private arbitration. And if they don't, then the case will be dismissed in 90 days with prejudice. That's how I would do it. So, and I know that's to me, that's a crazy frustrating thing because it seems like this is something that, the court should be glad they're getting this thing out of there. It's their contract. It's the creditors. It's the plaintiff's contract. The arbitration clause is, and they should force them to be, hold them to their own agreement. So that should be it. So, all right. Those are all great questions. And I appreciate all the information and feedback. Again, we do this each and every week, every Thursday night. If there's questions that you have or topics you want to talk about, bring them on here to the channel and we can go over them. Also, if there's other topics you want to hear, feel free to add comments to the channel on the other videos. I try to put out at least now 3 videos a week, plus this one. So you're getting at least 4 of the videos. If you haven't subscribed, please go ahead and do it. But hey, thanks for checking in tonight.